good morning, or I guess it's afternoon. I hate these noons because it's in between morning and afternoon, but good afternoon, everybody. Thanks for joining us. I'm Fiona DiDomenico, Regional President with Castle Group. Thanks for spending some of your day with us today. Castle, for those of you who may not be familiar with us, we are a privately held Florida-based company. We have over 1,700 teammates across the state and also in Texas, and we specialize in large-scale associations, both homeowners associations and condominiums. We have specialty in lifestyle, food and beverage, towers. And when I say large scale, it doesn't necessarily have to be a big number of units. We have, I think our smallest is maybe 8 or 9 units. So we do on-site management mostly. And we have a great home office support team that focuses and helps the field and on-site teams with training and support. So for those of you that aren't familiar, visit us at castlegroup.com. If you have any questions, you can just email us at info@castlegroup.com, and we'll make sure to follow up with you after the presentation. And I'm going to turn it back over to Adam. He's going to walk us through, and I am going to watch for your questions. So please do, as Gianna mentioned, type those in. And when appropriate, I will turn them over to Adam, and we'll do our best to answer them for you. So take us away, Adam.
Thanks very much, Fiona. And again, thank you to you and Gianna and Castle for putting this on. It's obviously a very timely presentation, given the news, even over the past couple of days, that there are a couple of systems that the National Oceanic Administration is watching develop. I don't think they're going to be an issue for us, but it's still, we have quite a bit of the season left. So I appreciate you putting this on for your committee members and directors and for any of the managers that are attending as well. Before we get going on the actual class, I'll just give you a quick background on myself personally and our firm, Arias Bossinger. So I've been practicing community association law the entirety of my career. I'm one of the few attorneys in this field that actually intended to be a community association attorney from the outset of not only my career, but really my legal education. So I've been tailoring my practice specifically for this area of the law. And our firm, likewise, is dedicated almost predominantly or almost entirely to community association representation. And so for the most part, that means post-turnover associations, but we do represent some pre-turnover associations, particularly in the transition phase, just to make it a little bit of a smoother process, both for the community and the committees that are involved with that on the membership side, and then as well even for the developers too, because you want to step off on the right foot in that circumstance. But our firm, Arias Bossinger, we currently have 8 attorneys in offices in Central Florida and on the coast. And one of the things that we've learned from the quarantine over the past few months is that distance is only a click away. So we have clients that span across Central Florida from coast to coast, up to Jacksonville, down to Sarasota, but really can go statewide depending on the circumstances. I am one of 4 board certified community association, condominium, and planned unit law attorneys in our firm. My 3 other partners, Carlos Arias, Sonia Bossinger, and Frank Lacquaniti, are also board certified attorneys, which is something that only about 200 or so attorneys across the state of Florida have that designation from the Florida Bar. So we're very proud of that. It's indicative of our experience and knowledge in this area, and we like to rely upon that to help advise our clients and see them through difficult situations, not only like the COVID-19 situation that we're dealing with right now, but hurricane. The old-fashioned disasters that we used to think of when we were talking about emergency powers. So
luckily this season we get to do both, Adam.
Yeah, so. That's right. Absolutely. Hey, and
hurricane with a dash of COVID.
Dust storm too. So So with that being said, obviously our contact information is going to be included in the slides. And if you have any questions, you're certainly feel free to reach out to us after the fact as well, and submit your questions as we go along, and Fiona will help moderate that. So, okay, Gianna, let's go ahead and start the presentation. Okay, so any Bob Dylan fans out there, here comes the story of the hurricane. So this is the class syllabus. There's a dirty little secret I have. I would love to be a college professor. So this is my out here where I get to do this. So we're going to cover a few things: insurance policy issues, emergency response vendors, preparing the property, and the aftermath of the storm. So these are our main topics that we're going to be going over today. So first up, insurance policy issues. And within this section, we're going to cover general policy considerations, pre-loss property conditions, and townhome HOAs. So, and you'll notice my tagline at the top there. That's definitely covered by our insurance, right? So, you know, I'm making a joke about it, but it is critically important. There's a reason this is the first slide in this presentation. When you're talking about a major disaster or a hurricane event, you need to make sure that your insurance policies have been written properly. They cover the property that you think they're covering. And the financial aspects of those policies need to be evaluated as well. And so some of the general things that we see, particularly, are the casualty insurance deductibles. And I put a range of the percentages up there that we see throughout the industry and throughout the state. And in North and Central Florida, we typically see the 1-2%. Usually 3%, sometimes 5% deductibles. And then in South Florida, we typically see the 5s and the 10s a little bit more, depending on the property conditions. But it is important because your hurricane deductibles can be very sizable. And there's a big difference even between 2% and 5%, particularly if you have $20 million worth of condominium buildings within your community. Getting to that 3% is going to be a lot more difficult than a 1% policy. So make sure you're working with quality insurance agents that have experience specifically in the community association field, and that they're doing their due diligence and writing your policies on a continuous basis, because these things can change from year to year. The other thing that I will point out about the casualty insurance deductibles, there's a little bit of a misnomer out there in how those are treated. A lot of people think that $200,000 that may be the deductible under the hurricane policy is something that the association has to come out of pocket for. And that is typically not the case. So it is truly a deduction from the funds that are being dispersed by the insurance company to fund those repairs. Now, not every policy is going to be the same, but in most circumstances that we see, that's how that plays out, which is why if you guys are maintaining a deductible fund that you can establish, you want to make sure that that's fully funded. But if it's not, there are certain things that you can do to address the financial aspects of reconstruction after a loss, where you're not having to come out of pocket for $200,000 just to get those insurance proceeds dispersed. The other thing that is critically important for community associations in the state of Florida is replacement cost versus actual cash value. And the reason for this is it will determine how the insurance company is going to evaluate your claim following the loss. And replacement cost is exactly what it sounds like. What is it going to cost to replace your roof, for example? Doesn't matter how old it is typically, or what other conditions there may be existing on the roof. Whereas the actual cash value incorporates depreciation over time. So if you have a 20-year-old roof or a 25-year-old roof and you have an actual cash value policy written on that roof, you're not going to be covered for the actual replacement cost of that roof. And the concept being, if you're paying less in premiums for an actual cash value policy, you should be perhaps spending more of that money funding your reserves. But when you're getting quotes from agents, it is not necessarily an apples to apples comparison. If you're just looking for what are my premiums going to be, you need to dig a little deeper to make sure you're getting proper coverage. The other thing that I'll point out for the replacement cost versus actual cost value, there can be endorsements at the back end of a policy that will actually convert what would otherwise be a replacement cost policy to an actual cash value policy based upon the age of a roof or a property component. So if it's 15 years old and you had that policy written when the roof was 12 years old, you had replacement cost value. But if you wait for another 5 years and you haven't reevaluated that policy and you just keep renewing under the same terms, you've now converted to a actual cash value. So be careful of that. For condominiums, insurance appraisals are required every 3 years. Now, this is something that is frequently confused with your reserve studies. So you have to do a reserve study for a condominium to be able to base your reserve funding and your reserve funds off of. Those are not required on a 3-year basis, although everybody thinks that they are required on a 3-year basis. What is required on a 3-year basis is the insurance appraisal, and that's simply to come in and evaluate what it's going to cost to replace your components. And it's a good thing too, because it can be, you can end up paying for more than what you need to pay in terms of an insurance premium if the value of the property has gone down from an appraisal standpoint. And conversely, you may be underinsured if the value has gone up for whatever reason. So that's important. So be aware of that as a condominium. For a homeowners association, there is no statutory requirement to have that insurance appraisal done on a yearly basis, on 3-year basis. So we have seen in many occasions where an appraisal hasn't been done since turnover for a homeowners association. And what can really be a problem with that, and you'll see this as a recurring theme, are townhome HOAs. And townhomes effectively, from the physical structures, appear to be and function like a condominium with shared walls and so on and so forth. So it's important to get that appraisal done at least every 3 years. And the other thing I'll touch on, general policy considerations, and this is a very important one as well, is the ordinance and laws coverage. And what this covers essentially are code enhancements that have been adopted in the building code since the property was built. So if you have a property that has a certain type of windows and it's valued based upon that standard of windows that is currently there, perhaps those windows are no longer code compliant. So when you go to actually rebuild the property and have that claim, you're not going to be able to purchase those windows for X dollars. You're going to have to buy more expensive windows that are code compliant. So it might be 2 times X value for those windows. So be sure to have that coverage if it makes sense financially for your association. Okay, so moving on to pre-loss property conditions. So an important thing for you guys to do from a claim standpoint, your insurance claims actually start before the disaster. They're actually going on right now, believe it or not, in how you are maintaining your property. And the reason for that being that one of the most common, if not the most common pushback arguments that we see from carriers is that the property wasn't maintained properly before the loss, or it was a pre-existing condition. So to combat that, it makes sense to evaluate and document those property conditions prior to the storm. And that's using video cameras, that's using pictures. With some vendors that we work with, they have proprietary methods of going inside actual buildings and doing kind of like you've seen it in real estate potentially, where you take a virtual tour within a unit or a building, so that if something is challenged in the future and said, oh no, these water spots were here before, you can actually go into this date and time-stamped video and see what the actual property conditions are. In doing that, you want to focus on areas that are typically damaged during storms. And, you know, I put this list down here: roofs, windows, sliding glass doors, because that's what we, you know, the layman's will think of. And I'm including myself in that category when it comes to property inspections. But it's something where you want to consider relying upon professionals that specialize in this type of repair work. The industry for doing a pre-storm inspection is maybe on the newer side. So you're not going to find as many dedicated companies specifically for that purpose. But most of the contractors and public adjusters and engineers have some type of proposal that can focus on these items. Personal property inventory. Association wants to, particularly if you have a nice clubhouse, you have pool tables, maybe you're a high-rise condominium and the lounge area is on a top floor and you have pianos up there, you have expensive personal property. These are things you want to inventory. If you have serial numbers, all the better. Create that inventory in one place so that you can refer to those when the insurance company is looking to substantiate your claim. And then maintenance records. I already touched on this a little bit, but just making sure you're consistently maintaining those records of what you're doing, showing a pattern of proper maintenance. You're doing it already, you're maintaining the property, you don't want to have to go the extra mile to prove that after the fact. Okay, emergency response vendors. And actually, before we get to this, and I'm so sorry, it looks like I left out a slide on the townhome HOAs. So I'll just discuss this real quick because I think it's an important topic for you guys to understand. For townhome HOAs, in the condominium context, so under Chapter 718 of Florida statutes, there is a statutory framework that dictates what the association insures and what each individual unit owner insures within a condominium. And without overcomplicating the explanation, it is essentially a unit owner is responsible for everything from the paint on the interior drywall in, and then the association is responsible for the unfinished drywall within the unit out. And so that is a fairly detailed and well-vetted system of a division of insured property. However, for HOAs, the statutory system reflects what you would expect a detached single-family home community to have, individual homes. The problem is if you have a townhome that is organized under Chapter 720 rather than Chapter 718, it is fully dependent upon your governing documents about who is insuring what property. We have seen this time and time again with our clients, with other clients and other community associations across the state, where a disaster happens. Perhaps the association is responsible normally for maintaining and repairing the roof, the townhome roof. And then when you get to the insurance section, it says that each individual unit owner is supposed to insure their entire lot property, including the roof, the structure, the walls, the windows, everything else that's on their individual lot. And I can guarantee you, this is not something you'll hear from attorneys much. I guarantee you, if you have that system, you have owners within your community that have the wrong insurance. meaning that they're purchasing through their agent a condominium style unit owner's policy that only covers the interior paint inwards, meaning that the roof, the structure of the building, the wiring, the piping inside, those are all uninsured against disasters. So what we typically do and recommend for our clients is amending your governing documents to permit the association to buy a master policy for those townhome HOAs. And there are a number of reasons of why that is a good idea. Sometimes financially, but predominantly from an administrative standpoint and ensuring that the property is properly insured. The last thing I'll note on this, because this is really, frankly, an entire class that we could give on this. If you have a community, townhome community that has 100 lots within that community and throughout multiple buildings, if each individual unit owner, even if they did have the proper insurance, which again is not going to be the case, if a tornado comes through or a hurricane comes through and lifts the roof on all of these townhomes, you're going to have 100 different insurance policies. You're going to have 100 different insurance carriers coming out. Who's going to coordinate with the roofing contractor in a building with 8 units? Is it falling under their insurance policy? What happens when there's a lapse in coverage? Does that person have the funds to help fund that repair? It is a complete nightmare for associations in that scenario. So please, if you're a townhome HOA, go back, look at your documents, talk to your attorney about whether or not you're insured the way you think you should be.
Yeah, that's great advice, Adam, because that for sure is a hot topic.
Yeah, absolutely.
This time of year. So great guidance.
Okay, so emergency response vendors. So these are, you want to build your response team. These are the categories we'll look into. And then we're going to address pre-approval of contract terms for those emergency response vendors as well. Okay, so don't wait until after the storm. This is something that you want to take care of ahead of time. So create a call list. You don't want to be fumbling around looking for, what numbers to call. You want to look at special management numbers. So I don't know if Castle has this during emergency response, but oftentimes community association management firms will have dedicated numbers in certain circumstances. Fiona, do you guys implement that system?
We do. So we have, we actually have a whole CERT team that we, sort of the command center during hurricane season. And so our team has a special number they can call. And for our residents, we always have an emergency line operational. And we have all of our associations organized so that we know, who the manager is, who their buddy manager is. And we literally have a call tree. So just like you would normally do with your own, friends and family, we have that implemented for your sites. And we also recommend for all of our communities, we put together a whole, what we call a hurricane plan and binder. One goes out to the residents that talks about locally, where the shelters are, what the evacuation routes are, important, numbers, emergency management numbers, emergency management apps, all of those things that they should have specific for their community. And then in addition, we'll do, the property manager does a whole assessment of the actual association and thinks about when a storm comes through, where are they going to do the staging area? If you've got, hundreds of trees down, well, those all need to be chopped, and where are you going to put all that wood? And, everything is looked at from that aspect, and it's all put into a written plan so that, gosh forbid, something happens to the manager and they can't get to property, another castle manager can step into their shoes and literally grab the plan and go and execute.
Hit the ground running.
Yeah.
Yeah, and that's great. And I wouldn't expect anything less from Castle, frankly, because you guys have been a leader in this field for a while. But that is something that you want to have available. So particularly for those on the call, make sure to reach out to your property management to make sure you have that number. The other things on the list, insurance agent, you want to have that number available, your attorney, your legal counsel, and any restoration vendors that you might need to contact on an emergency basis. So you need to, this is something that is not commonly done by associations. It's not a requirement by any stretch of the imagination. This is a best practices method here, is to evaluate those restoration and response vendors ahead of the storm. And the reason for that should be fairly obvious. If you are waiting until a hurricane that, and let's take Irma, for example, that came up basically the entire state, the entire length of the state. If that happens, there's going to be a mad rush on getting contractors and restoration vendors to come to a property. And by evaluating those vendors ahead of time, you can hopefully reserve your place in line, depending on what you can negotiate with those vendors, so that you have priority if and when that disaster happens, for them to come to your property sooner rather than later. The other aspect of that is that it gives you an opportunity to actually comparatively shop for these vendors. You can go through a bidding process or an interview process, or be still my heart, reviewing a contract before you sign it. Because otherwise, and I don't blame associations for being in this position if they haven't done it beforehand, but sometimes necessity makes you skip over some of those analysis steps in the aftermath of a storm, simply because you need to get things done. And that's just the reality of this situation. So doing it ahead of time lets you go through a normal pace of evaluation. You can have your attorney review those contracts ahead of time and negotiate those terms. The contract terms that specifically for hurricane response, you want to look at scope of work, particularly for emergency restoration contracts. And I'm not talking about if your roof is damaged and you end up needing to have an entire roof replaced. That's the ultimate restoration project. But the emergency restoration work is drying out the interior of the building, making sure that it is tarped roofs, making sure that there's at least some temporary mitigation of additional damage that could occur from the elements. And you don't necessarily want to sign a contract that includes the entire project of restoration, from putting those first fans on the property and putting those first tarps on the property, all the way through, putting the final coat of paint on the stucco on the outside of your building. You may, if you find a vendor that you trust and has the expertise to do all of those items, but otherwise you want to see those initial responders having their contracts limited to that initial remediation work. You can also ensure that the contractors themselves have proper insurance, including listing the association and property management as additional insureds on their own property policies. And this is something, again, if you're waiting until after the storm and the mad rush to get these things done, you're not necessarily going to be able to either incorporate that, maybe it's not provided for in the contract at all, or verify that it's been done correctly. And a public service announcement that I always give to my clients and property managers that we work with is that the certificate of additional insureds is not in and of itself enough to bind coverage for your community association or management. There has to be an actual endorsement. Depending on the endorsement form that is used, you sometimes need privity of contract. So when you're looking to verify that you've been added as an additional insured and you actually have coverage under that policy, you need to evaluate those forms as well. Indemnification and liability limitations. These are, again, standard legal paragraphs that we like to evaluate under any circumstance, but particularly when you're talking about restoration work, because you're going in and having sometimes structural aspects of the buildings repaired and addressed, and you want to make sure that the association is adequately protected there. And the other thing that I threw in here is time is of the essence. So you want to be able to include some type of provision that can hold the contractor's feet to the fire if they're not proceeding with work as needed. And the reality of the situation after a storm is that perhaps the contractor isn't able to provide the services that your association needs. And through no fault of their own other than a shortage of personnel. But you want to be able in that circumstance to potentially get out of that contract and move on to another restoration vendor that has the capability of performing those. So that's something that people don't necessarily consider, but that's something that needs to be addressed.
Yeah, and I just to mention there too, you mentioned, time when there is a storm and you've got significant water penetration, the faster you can get that under control, the easier the rest of the project goes. So having that coordinated ahead of time, you don't want to be trying to scramble in the 11th hour when all of your neighbors around you are scrambling, all making the same phone calls. You'll have a much better experience if you can get that organized up front.
Absolutely. And that's true for basically every damage claim, whether it be a construction defect or an insurance claim or even a maintenance issue in your condominium, particularly for high-rise or multi-story condominiums, because if something happens on the upper levels, where does water go? Down. And actually it goes down and across, it moves laterally, it gets into the crevices that you would have no idea that they were there, and water will find its way there and create problems for the association. Okay, so the next section is preparing the property. So this is actually doing the physical property preparations. And the short and sweet for this section, we're going to address hurricane shutters and preventative measures, and then community-specific checklists. So for condominium associations, this is not for homeowners associations. So if you're an HOA, these rules do not apply to you, although your individual governing documents may have provisions that guide you on this. But for condominium associations, the board is actually obligated by statute to adopt hurricane shutter specifications that include color, style, and other factors deemed relevant by the board. So this is, everybody has a set of rules and regulations, but this is something that is specifically mandated by statute that the board address ahead of time. So if you have not done that, that is something that you should do in your next rule revision. And you maybe want to think about doing that sooner rather than later, given we're just entering July here. For unit owners, they have the right to install approved hurricane shutters pursuant to those specifications that have been adopted by the board, including impact glass as well, and other code compliant windows or doors or other types of code compliant hurricane protection on any portion of their unit. So the reason I emphasize code compliant, I don't know if you saw the invitation for this webinar, but I made a reference to, do owners have the ability to put, I'm at a loss now, the wood that goes on the exterior of the plywood. If you're putting composite plywood on the exterior of your windows, this happens, everybody runs out to Home Depot, they buy a couple of sheets. If it hasn't been sold out by that point, they come back and they put it on the exterior of the building. Well, if you're in a garden style condominium and the association maintains the exterior stucco and even the windows, we have questions all the time. Can the owner go in and drill holes into the exterior stucco to put these pieces of plywood up over the windows? And our opinion is that they are not permitted to do so, at least under this statute, because drilling plywood into the side of your stucco buildings, I would not classify as being code compliant. So It's one of those things where you want to address this ahead of time, and perhaps it's a unit owner education process as well, to encourage people to take proper actions ahead of time without having to rely upon the boarding up right at the last minute. So unit owners may also allow the board to install hurricane protection measures as the association by a majority vote. So if your community wants to do that, you can have that vote. Community-specific checklist. So the checklist itself, I put this up here. Create the checklist. No one knows your community better than you as a resident in that community. You can use other people's checklists. You can go on the internet and find 100 different checklists of what you can and cannot or should and should not be doing ahead of time to secure your property. Use those as a basis. Use Fiona's checklist as a basis to go through and walk through your property and make sure those things apply. And if there aren't things on that list that apply to your community, go ahead and add them so you're not going through and trying to remember everything in the future. But cleaning gutters, trimming and thinning trees, ensuring proper drainage on your property. Make sure your generators, your backup generators are properly working and that their exhaust is properly working. That's actually the #1 public health risk following a storm, is not properly ventilating generators. Water shutoff valves, make sure you know where they are, 1, and 2, that they work. And for condominiums, you can shut down the elevators, the electricity, and the water supply to the building, and if there's a state of emergency. So if you're having to evacuate your building, you can and should shut these systems down. And then the other thing for garden style condominiums and homeowners associations that are gated is making sure that those gates are open and secured. And this is one of those caveats to security, essentially being that you need to make sure people can get in and out, and more importantly, for first responders to get in and out as well. Okay, aftermath of the storm. We're going to cover initial property inspection, mobilizing your team, and the association emergency powers. So the initial property inspection, proceed with caution, please.
This is a huge one.
Yes, absolutely. So, and it's common sense, but we got to put it in there because, you know, the matter of fact is residents are actually the first responders. So the people that are on this call that are board members or committee members or unit owners, what does everybody do first thing the storm, after the storm stops? You walk outside, you take a look around, you go to your neighbors, you look to see what damage has happened. So when you're doing that, just make sure that you're doing it carefully. And I put this down here. This has nothing to do with the law, but be neighborly. Mother Nature is a very powerful equalizer. So just be sympathetic to our common humanity. We all have a lot of differences right now in terms of opinion and politics and so on and so forth. But when we're stripped of our power and water and shelter, we need to fall back and operate as a community. And in a strange sense, I'm a lifelong Floridian. It's always almost encouraging in the aftermath of a storm to see how people come together like that. So next thing, safely identify and document the scope of damage. So if you have people that are going out and walking around the community, again, from a distance of any dangerous conditions, take a picture of that limb on the roof. Take a picture of what has actually occurred to help with the claims process potentially. And the other thing I put down here is consider the creation of a hurricane or disaster committee. And this is, you know, I put this in the aftermath of the storm, but you can consider that now of creating that committee so that if and when a storm does come, you have a group of individuals that may include some directors, but also some non-directors or non-officers on the board that knows what to do, that is in charge of, taking pictures. They're familiar with the checklist. They're familiar with your community systems. Because the other thing to realize, and this is just the reality of the situation, if a storm comes through, again, like Irma, and it covers the entire state of Florida, the people that you normally and rightfully rely upon to be prompt in their service and response may have their own issues that they're addressing, both with their own homes or from a unavoidable client service standpoint. You're not necessarily going to have, particularly for a portfolio manager, which, fortunately, you're not going to have as many issues with Castle because of their dedication to on-site. But if you do have a portfolio manager, or you're currently using a portfolio manager, they're going to have every single one of their communities asking them to be at their community at the same time. And that doesn't happen. So you need to have some contingencies there, not only from the management side of things, but even within your community to make sure you can address those items on a timely basis.
Yeah, and Adam, it's a great point in that it really helps the manager as well. If the manager knows that a certain group of individuals are going to, sort of being their eyes and their ears on property, it can really help the management company triage, especially if they do not have a full-time, manager and they're doing portfolio. So they can know, the people are calling in and saying, here's what's going on at, this community. You may not need somebody right away there, but you might need somebody next door. That's what happens with storms, is one community is fine and one street over is a complete, disaster. So yeah, it's a great idea.
Yeah, absolutely. Mobilizing your team. Again, this kind of reflects the list of what you do ahead of the storm. So hopefully when you're in the aftermath, things are actually a little bit more smooth just because you've thought through the process. But contact your property management, contact your insurance agent, contact your attorney, and as needed, contact your pre-approved emergency response vendors. And I put this note down here as well. You have an obligation under your casualty insurance policy to mitigate further damage. So this is not something where you wait until the insurance company adjuster comes out or wait for the claims process to occur. You need to prevent further damage from happening on your property. And then potentially a public insurance adjuster. So, and I think I'm going to get to this in another slide here, and perhaps the next slide. But and no, I think it might be one after that, but that's okay, Gianna. But the public insurance adjuster, you just need to be aware that that is a completely different position than the insurance adjuster that is provided by your insurance company. So you potentially could want to engage with a public adjuster as well.
And on that note, I just wanted to let everybody know too, when a disaster does happen and you're out walking around, what can happen is people will walk up to you because you're the person with the clipboard and the pen and the camera, and so they see you, and the next thing you know, you think you're talking to your insurance adjuster, but you're really not. So my words of wisdom, having it happened to myself being on property when disasters do occur, is as you said, don't sign anything. Make sure you take a breath, speak with your legal counsel, and measure twice, cut once, as we like to say.
Yeah, exactly. Absolutely. And Gianna, our master of ceremonies, did find my slide on the next one. And I put here, do not rely on adjuster that's sent by the insurance carrier. The reality of the situation is the insurance companies can face personnel shortages after a storm. And the people that they send out can be inexperienced or from out of state that don't know the type of damage that you would see from a hurricane. And overscheduled adjusters can overlook the extent of the damage. So you want to be able to engage reputable attorneys and public adjusters that you frankly should know of ahead of time. And this is one of those things where you have to be cautious in the aftermath of a storm, because there can be a lot of people that are pop out that are looking for business. And you want to use the people that you trust and know of already. And the other thing is with attorneys and public adjusters, most will offer contingency fee arrangements for those services as well.
And typically what we do is we we get with the board and the property manager and we say, okay, what do we think the scope of the damage is? Obviously, we're not experts, but we can, kind of eyeball and see, okay, this is going to be a major claim, or, we're going to be okay here. And then we get on the phone with the association's attorney is always our recommendation. Let's walk through what we think we know together. And then, with everybody's experience, we put a plan in place.
Yeah, perfect. That's the best way to do it. And I think the previous slide with getting everything in writing, that's self-explanatory. But it's, again, it helps with if you have those pre-approved vendor contracts, it helps with efficiency and cost, because then it's just a matter of course to get those things signed. And I love the request from clients when they say, here, we signed this contract. Can you take a look to see if we need to change anything? Well, that's putting the cart before the horse, because if you signed it, it's already done. I can't do much about it. So.
Yeah. And just so you know, time, Adam, we're about 12:48, and we do have a few questions to answer. So.
Okay, I'll skip through these emergency powers here as quickly as possible. You guys are probably familiar with these already, given our current circumstances. But if a state of emergency is declared by the governor, condos, cooperatives, and HOAs have emergency powers that come into play that can be exercised when reasonably necessary to protect the health, safety, and welfare of the association. They include conducting board and membership meetings with less notice than would otherwise be required under the law. You can cancel and reschedule meetings. You can name assistant officers with the same officers as the primary officers. So assistant president, assistant vice president, so on and so forth, which incidentally could also be your hurricane committee. So you could have a hurricane committee, and those could be converted into assistant officers in the aftermath if need be. Again, the ability to shut off certain community systems to prevent further damage, declare portions of the property unavailable for entry or occupancy if you have significant damage in your community. You can evacuate the property if a mandatory evacuation order is in place. You do not have the independent authority as a board to kick everyone out of the community without a governmental order. You can contract for the removal of debris and to prevent or mitigate the spread of fungus by removing and disposing of wet drywall, insulation, so on and so forth. For condominiums, this includes the individual units, removing that damaged wet property. And for HOAs, it's limited to the association property. So again, remember that with townhome HOAs, if you're a townhome HOA, perhaps you want to include some type of emergency response provision that allows the association to remove those wet items from a unit. Okay, so the board may also levy assessments without a vote of the owners, regardless of what is required in the governing documents. Put this down here, I know what you're thinking, and the answer is no. You cannot use this to fund a project that you've been looking to fund for a long time, but haven't been able to reach quorum. This is something that has to be in response to damage caused by an event for which the state of emergency is declared. The association can also borrow money and pledge assets as collateral to fund emergency repairs if if operating funds are insufficient without an owner vote. And so sometimes community association governing documents have what are called anti-hypothecation clauses, which prevent you from using the association's assets as security and obtaining a loan. And so when these emergency powers are put into place, that's something that you can take advantage of. For condos only, associations may contract on behalf of unit owners for items or services that are normally their responsibility when necessary to prevent further damage. That includes drying out the units, boarding up windows, replacing AC units that have been damaged to provide climate control, and any other necessary task. And the unit owners must reimburse the association for the actual costs of those services and items, which is enforceable by lien rights, just like a regular assessment would be in any other context. But this is for condominiums only, so be aware of that. And there we are, only a couple of minutes over. So
how's that for timing? Great job, Adam. So we had a question was, typed in, and it's going back, I think, to the townhome question. It says, regarding paint inward, guide on property ownership, who owns windows and sliding glass doors, the unit owner or HOA? So I think they're talking about in a townhome.
Yeah, so, and this is the perfect example of this type of problem. So in a townhome, we don't know. Well, actually, the ownership of it is the individual owner. So if you have a lot in a townhome community, you own those windows, but it could be the maintenance responsibility of the association if it's transferred, and it could be the insurance responsibility of the association if it's transferred. But the best way of looking at this to be able to answer the question yourself is, for a townhome HOA, the law looks at it as an individual freestanding building that you own. And in any other context, that is all the property owner's responsibility, period. The only way that you can transfer some of those responsibilities as the owner of the property is through an agreement, a contract, covenants, and restrictions. So it's all your responsibility unless something has been delegated to the association in your governing documents.
All right, great. And then we had a question about Volusia County, Florida. Do they have an emergency operations center? And how should we, the resort, work with them? I can tell you from a management experience standpoint, yes, they do, absolutely. Pretty much every county has an emergency operations center. You should Google it, and most of them now have apps that you can actually download on your phone, and they give you a lot of information. They also, a lot of them will communicate in an emergency on Twitter, for example. So it's great to follow them there because you'll get up-to-date information. And then it's very community specific in my experience. Some emergency operations centers, depending on the size of your community, they have a community liaison who reaches out to the associations. Others are smaller and don't have that, so each one's a little bit unique. But I would start with, looking at their website, downloading the app, and following them. I don't know, Adam, if you have anything to add on that one.
No, I mean, it's essentially you covered everything. They have them, and you should be working with them, but it's going to be different from county to county. And Volusia certainly has that policy as well. So.
Yeah. Okay. And then another question that came in was regarding email blasting for unit owners. I think the question they're saying is, if we're going to email blast out to the unit owners to take in their furniture, so in a condo scenario, if it's on the balcony, bring your furniture in, and let's say they leave it out there, can management then bring it in? And if so, what is a reasonable fee? Do you have any thoughts on that?
Yeah, that's a great question. And it, to some extent, it depends on the risk tolerance for your association, because the reality is somebody's going to challenge your authority to do that. In our opinion, particularly in a state of emergency, you would be able to protect the rest of the association's property if those things are going to be airborne, if it's items that would be coming off of the property, and particularly from a balcony standpoint, those are usually limited common elements. And even though there are individual use rights, it still gives the association additional authority to be able to enter the units when necessary to protect and prevent additional damage to the condominium. So moving it inside, it sounds great in principle, but at the same time, if you go into a limited common element and there's this giant bookcase and there are, there's an anchor that's been affixed to the wall, those sorts of things. It's a case-by-case basis, but I do think you have the ability to come in and do that.
Yeah, and I can tell you from a practicality standpoint, so communicate, and educate your residents. So don't wait until, 36 hours before the storm to send an e-blast out. What we like to see is as I mentioned earlier, a hurricane plan that goes out to the residents that reminds them if there are balcony scenarios or furniture scenarios that needs to come in. And then really reminding them throughout storm season. And then I have had it happen in a tower community where someone's left something substantial on a balcony. And for sure, get with your legal counsel and get something in writing, document, because it's the old thing my mom says, no good deed goes unpunished. You got to move it normally because it's a threat, but it'll be the one time you do it and something breaks and then the storm didn't come. And guess what? Who comes knocking looking for their table to be replaced or whatever. So speak with your attorney. I can't emphasize that enough before you do that.
Yeah, and get something in writing. Like Fiona said, this is one of those things where, from everybody's perspective, the owners, the association, property management, even the attorney, you want to have something in writing on that because the other thing with those big items, you can move it, but where are you going to put that?
Right.
Where are you going to put
Exactly.
the property? That's somebody else's property still, so that can be a complicated situation as well.
Yeah. Okay. And then one of the last questions is the condominium association responsible for knowing who has not evacuated if mandatory evacuation has been issued?
It's a great question. And the way the statute is written, it makes me a little bit uncomfortable, but there is a specific provision in the governing documents that even if there is an evacuation order, the association is not liable for owners that choose to stay if you're implementing those evacuation orders as well. So, going through your community and trying to inform them either through your broadcast system or notifications, those are all things that you can and should do. But the quick answer is no, I do not think that you're going to be liable or responsible for forcing people to evacuate and keeping a tally of that. There is still some personal responsibility that people have for their own safety and well-being.
Right. Okay. And last question says, can you speak to a little bit regarding drainage prep and the inspection protocol? So I can tell you from a management standpoint, again, part of the regular preventative maintenance plan, whether it's in a large-scale HOA going through and looking literally at all of the drainage points, are the grates cleared out? In your clubhouse areas, are the eaves cleaned out? That should be part of the regular maintenance plan. And again, documented and followed up on prior to a major storm. I don't know if you have anything to add, Adam, from your end.
No, other than insurers wanting to verify that all of those things have been taken care of, even more so over the past few years. They will actually go around and do inspections before a storm themselves to evaluate whether or not you have vegetation approaching the building, whether you've cleaned your gutters. So especially if that has occurred and you don't know of it necessarily, you want to make sure that those items have not only been corrected, but you've documented that you've corrected those issues as well.
Okay, excellent. Well, that is all the questions we had, and look at that, right on time. So thank you so much, Adam, for your time today and for all of our participants. We really appreciate everybody being here, and definitely reach out to us if you have any questions. We are happy to follow up with you after the webinar.
Thanks so much, everyone, for attending.
All right, have a great day.
You too, Fiona. Thank you, Gianna.
Bye-bye.